Hello, my name is Chris Meyer and I'm a partner at Goepel, the LegalShield provider firm in British Columbia. I have the privilege of being the LegalShield managing partner. Every 3 months or so we have an open house reception for associates, members and guests at Goepel to introduce them to our firm and some of our lawyers and staff. During those meetings we usually take them on a short tour of our offices, provide food and beverages and quite often give a talk on some or other issue that we feel may be of interest to everyone. Unfortunately, many of the LegalShield associates and members do not live in the Lower Mainland and as such have no opportunity to join us, get to know us and hear our talks and comments. So I thought it would be a good idea to introduce our firm and give a very broad outline on estate planning issues on our website. So here we go. The first slide is the reception area on the 17th floor. We also have space on the 16th floor, but the 17th floor is where we have our receptions. Goepel was founded in 1985, has 38 lawyers and 52 staff, and we've had the pleasure of being the LegalShield provider firm since 1999. In the LegalShield department, we have 4 lawyers whose primary responsibility is telephone intakes, review of documents, preparation of letters and wills, and all the other services a LegalShield member is entitled to. We also have a staff of 5 assistants on our team. As the membership grew by 27% last year, and seems to be on track for similar growth in 2014, I have no doubt that the department will be increasing in size very soon. This is the view of our library on the 17th floor. This is the boardroom where we socialize with associates, members, and potential members, serve food and drinks, and give the talks. We are fortunate that quite often there are more people than the boardroom can hold, in which case the overflow goes into the reception area where, if I talk really loudly, they can still hear me. I've spoken to literally thousands of LegalShield associates and members by telephone, so I thought it might be a good idea to show what I look like. I thought I'd pick a picture taken a few years ago when I still had a little more hair, but that doesn't seem to have made a difference. What a sad state of affairs. Now that you have seen a little of our office, I would like to do a presentation about estate planning in very broad strokes. I have taken a PowerPoint presentation produced by the LegalShield head office and have amended it where necessary to reflect British Columbia law. I hope you will find it to be of interest and would encourage you, if you have any questions, to make use of your membership and call Goepel for answers. Your calls are always welcomed. Thank you. We are here to address a problem that affects more than 60% of Canadians, dying without a will. Various surveys and studies over the last 10 years have consistently shown that over 60% of all Canadians die without a will. It's a big problem. 3 of the most common reasons cited by survey respondents for not having a will are procrastination, a belief that they don't need one, and cost. The will benefit available with the LegalShield membership helps to solve all 3 of these problems. Today our discussion will cover the following topics. First, what estate planning is and why each person needs to do it. Next, we will discuss the 3 biggest challenges to doing estate planning and remind you why your LegalShield benefit addresses each of those challenges. Next, we will discuss basic estate planning techniques. Finally, we will address the key parts of the Will Questionnaire so that you can finalize your questionnaire and have us here at Goepel prepare your will. Let me make one comment. This is general information I am giving today. As you will see at the bottom of each slide, I remind you that you can always call Goepel at any time you have questions specific to your particular estate planning needs. So, let's get started. Your estate includes all the assets that you've accumulated during your lifetime. It includes real estate, bank accounts, stocks, bonds, retirement plans, vehicles, household goods, personal effects, and anything else you own or control, such as life insurance, or your business. Estate planning accomplishes 3 goals. First, to manage your estate during your lifetime. There may be events in your life such as an accident, chronic illness, or debilitating condition that prevent you from managing your own finances. Anticipating these situations and making calm decisions now rather than under stress when one of these events occurs will help others make informed decisions on your behalf later. If you wait until it's too late, it may be necessary to have an expensive and time-consuming court proceeding for an order of committeeship to designate someone to manage your finances. Second, to arrange for timely and cost-effective distribution of your estate upon your death. If you have a clear plan of what you have, to whom it goes, and in what proportions, that can reduce problems, costs, and taxes, and can ease the burden of your death on your loved ones. Finally, a good plan will help you avoid probate where possible. Probate adds extra time, cost, and hassle, so avoiding it is usually a much better option. However, probate doesn't present the same issues in every province. In some provinces, it's very costly and challenging. In other provinces, it's simple and not expensive. In British Columbia, if probate is required, there are probate fees payable to the province of British Columbia equal to approximately 1.4% of the gross value of the estate. There are consequences to poor estate planning or no estate planning at all. First, if you don't explain your plan clearly, there could be incorrect assumptions about what you would want, and your wishes may not be carried out. No planning or poor planning could lead to going through probate unnecessarily and higher costs of distribution. Poor planning could lead to higher taxes and less of your estate going to your loved ones. The challenges to completing your estate planning are finding the right lawyer. Criteria should include someone who is knowledgeable and skilled at estate planning and has a good reputation in your province. LegalShield took care of this for you. Getting it done. It's an important task, but for many it isn't urgent. It also may seem like a project that will take a lot of time. LegalShield makes it much easier for you to get it accomplished. No need to leave your home and no missed work. You have friendly and knowledgeable lawyers who will keep you on track to complete the project. Choosing the technique that is right for your situation. Again, that's why your LegalShield plan is so valuable, because you have easy access to a lawyer to help you decide the right plan for you and then help you implement the plan at no cost or at a discounted fee. There are some common options that are used for estate planning. This is just an overview. 1. Intestate. No planning at all. 2. Powers of attorney. Financial. 3. Representation agreements. Medical. 4. Jointly held assets. 5. Contracts. 6. Inter vivos trusts. 7. Last wills and testament. Now let's talk about the options in a little more detail. Intestacy, or dying intestate, simply means that you died without a will. Each province has a law of intestate succession, providing to whom and in what proportions your estate passes in the absence of a will. It's what the law presumes to be your estate plan. Problems arise if you have more than one marriage, or if you had a divorce, or if you have stepchildren, a blended marriage, or if you want all of your estate to go to your spouse first and not be divided between your spouse and your children, and excluding all stepchildren, and from many other situations that arise in our lives. In British Columbia, for example, if you die intestate, only a certain amount is paid to your spouse, and the balance is divided amongst your spouse and your children in equal shares. This could result in your spouse ending up in a difficult financial situation without enough money to support her for the rest of her life. Having these two agreements is a very important part of a good estate plan. One kind, the general enduring power of attorney, also called a financial power of attorney, designates someone to make decisions regarding your assets, or your dollars, when you are incapacitated physically or mentally. The other kind is called a representation agreement. It designates someone to work with doctors and make medical decisions and other living-related decisions when you are incapacitated mentally or physically. It sometimes contains an advance directive, which is that part of the document where you can give instructions about whether to maintain your life using heroic measures, like life support equipment, or not. There have been some very high-profile cases in the past regarding people who failed to have these documents and the problems it caused. You can also use the technique of owning assets jointly with right of survivorship. Upon the death of one joint owner, their interest passes automatically to the surviving joint owner. Assets owned this way pass without regard to the contents of your will, without probate and without the possibility of being challenged under the Wills Variation Act of British Columbia by a disinherited spouse or child. Creating a joint interest in property should not be done without discussing this first with the lawyer at Watson Goepel. Certain asset transfers can be controlled by contract. For example, proceeds from life insurance, annuity contracts, RRSPs, RIFs, TFSAs, and pensions will pass to whomever you have designated as your beneficiary on the beneficiary forms associated with those contracts. Just like jointly held assets, contract assets will pass without regard to the contents of your will and without probate. It is important to coordinate the beneficiary designations in contracts with the provisions of your will to ensure they work in concert with one another. An inter vivos trust is a trust that you establish during your lifetime. Everyone should have a will, but not everyone should have an inter vivos trust. Inter vivos trusts can be very effective, but can also be complicated. We strongly recommend that you speak with a lawyer at Watson Goepel about whether a trust is right for you, and how to go about getting the right help to get one set up if desired. A will is a document that designated the persons who will receive your estate and in what proportions upon your death. It also addresses who will oversee the administration of the estate if probate is required, and addresses issues such as guardianship of minor children and management of assets left to minors. Both the named member and the named member's spouse should have a will prepared. Having a will itself does not avoid probate. The Will Questionnaire is not your will. It needs to be completed and sent to Watson Goepel in order to begin the process of having your will prepared. The process is completed when you sign your will according to instructions given to you by Watson Goepel. We remind you to work with us at Watson Goepel to understand how the information presented here applies to you. Most importantly, we urge you to not delay in getting your estate plan taken care of. In that light, let's now switch to some instructions to help you complete your Will Questionnaire. As you work through the questionnaire, you may have questions or concerns regarding your responses. We at Watson Goepel want to hear from you. Make a list of your questions or mark the places in the questionnaire where you have questions and call us. We're familiar with the questionnaire and are happy to help you complete it. We want to highlight several questions in the questionnaire that may need special attention. We are going to work our way through the questionnaire starting on page 1. Please make sure we have all the information asked for. We need your full legal name and all the identifying information listed. Please let Watson Goepel know if either you or your spouse has been divorced. Indicate which spouse and if there is a divorce decree that still has an effect on you. Please send a copy of the decree with the completed questionnaire. An example of a divorce decree that still may have an effect is one that provides that life insurance must be carried until the children turn 21. We need the full legal names of your children. Please do not use nicknames. How to treat stepchildren can be a thought-provoking question. Spend time thinking how distribution to all the children in your life could affect their relationship with each other. In British Columbia, a stepchild who has not been adopted has no legal right to challenge your will under the Wills Variation Act and is not entitled to any part of your estate if you die without a will. Picking the people who are going to be responsible for carrying out your wishes takes some care. The personal representative or the executor and guardian for children are important choices. We recommend that consideration be given to responsible family members or close friends or both. You are asking these individuals to take care of your children and your financial affairs. Before designating someone, make sure you call them to discuss this very important decision and make sure they are able and willing to take on the responsibility. Remember, you can have joint guardians, but then you will have to consider what happens if they divorce. Do your children move to the alternate guardians, or do they stay with one or other of the initially named guardians? Your assets and liabilities page does not have to be exact. You can use ballpark figures if you choose. This page is more of a reminder of other types of assets you might have overlooked, and a note to the estate of any debts you may owe that need to be paid. It also gives us a chance to make some suggestions that might save taxes or probate fees when you die. The executor or personal representative is an important decision. This person has the responsibility of making sure your estate is distributed correctly and any debts and taxes paid accurately. Please call your choice of executor to make sure they are willing. Remember, you can appoint joint executors if you wish, and you should always name an alternate or alternate executors. Typically, the executor will also act as the trustee of any trusts you create in your will. These trusts, called testamentary trusts, are often created for minor or disabled children. If you do create trusts for your minor children, Consider carefully at what age they should receive their share of your estate. We typically advise our clients that 19, which is the legal age in British Columbia, is just too young to receive much, if anything, and usually suggest 21 or preferably 25 before they take. If you have young children, we sometimes recommend that as a last resort, that is, after you have named an executor and an alternate executor, you name a trust company, simply to make sure that your wishes in your will are carried out properly and your estate is properly looked after in the event none of the executors survive to complete the trusts set up for your minor children. If there are items that are important to you that you want to go to someone, this is the place to tell us. Please be specific. Terms such as heirloom, collectibles, contents, and memorabilia are just too vague to identify the item to be given. My mother's 2-carat diamond ring in the turquoise setting is much better than my mother's ring. This is a good place to add pages as necessary. This paragraph is the heart of the questionnaire. Answering this question tells Watson Goepel what happens to your estate when you die. Consider the options presented. If the options do not set out what you want to do, write out what you want to do either under option C or on a separate piece of paper. Be as specific as you want. Let us worry about the wording. Please remember that your will does not control who will receive jointly held property, life insurance, RRSPs, RIFs and TFSA proceeds, and pay-on-death accounts. Naming your nominees for the power of attorney for personal care, otherwise known as the representation agreement, and the continuing power of attorney for property are very important decisions. These are persons to carry out your health care and financial wishes if you are unable to. It can be your spouse, adult child, or close friend. You can name joint representatives or attorneys if you wish. Remember that it is essential that you name alternate representatives and alternate attorneys as circumstances change, and you cannot force someone to act on your behalf if they do not wish to do so. That's it. We're finished. Please remember to call us with any questions you might have written down. Once you have completed the questionnaire, please send it to us as soon as possible. See, that wasn't so bad. 30 minutes is all you need to start and complete the process of securing your family for the future. Because every situation is different and every family is different, please understand that this program was developed to give you an overview of the process. You should not rely on this overview for legal advice. Legal advice is what we at Watson Goepel are for. Please call us to get this process completed. Thank you for being a valued member of LegalShield and for taking the time to listen to me.